Hello, good morning. Welcome to today's webinar. This webinar is one in a series provided free to our clients and partners and can be set against your continuous professional development requirements. It's been recorded and will be available to download from the website, from our website in due course. Our webinar today will highlight some of the things that you can do to prevent disputes with clients and partners and suppliers, customers, what to do, and also what to do if you end up in a dispute situation with them. From time to time, commercial relationships do go sour, and when they do, any resulting legal disputes between businesses can be very time-consuming, costly and stressful for everyone involved. So today we're going to consider how to reduce the risk by taking certain steps at the outset of a commercial relationship, and what to do, how to best deal with it and prepare for it, so if a dispute happens. My name is Mark Craig, and I'm Associate Director for the Company Secretariat team here at Jordan's. I'm joined today by my colleague Simon Bates, Executive Director Solicitor at Corporate Law. So let me get the slides started. Should have clicked on the slides there. We've got on screen, you can see some of what Simon's specialities are, so to speak. He advises clients on contracts and legal compliance. We've also got joining us our friend from Loney, Stewart, Holland, Scott Taylor.
Hello.
Again, on screen, you can see Scott handles contracts disputes, professional negligence claims, that's easy for you to say, ombudsman complaints, reputation, information claims, contingent insolvencies. Due to the large number of attendees on the call today, you've all been put on mute for the duration of the webinar. However, as it's designed to be an interactive event, I'd be grateful if you could email me with any questions throughout the session at mark_craig@jordans.co.uk. Let me just put that on screen again so you can see the email address there on top right, mark_craig@jordans.co.uk. Any questions we don't get through today, we'll answer by email after the event. So without any further delay, let me flick on the slides again. We're going to talk first about prevention, and Simon's here and talk to us about that subject. So over to you, Simon.
Thank you, Mark. Good morning, everybody. My approach this first part on dispute prevention will be to consider some common areas where disputes arise, and in each case look at what might be done at the outset to prevent that dispute arising. Sometimes, of course, you can't prevent a dispute, so I'm also going to consider some steps to put you in a better position, which in turn is going to make a contested dispute less likely. I'm very much going to look at this from the perspective of a commercial transaction. So think about buying or selling goods or services and what might go wrong. There are, of course, a multitude of things that can go wrong, but I'm going to concentrate on the 4 common areas which I've listed on this slide. Now, although I'm going to look at these 4 areas individually, many of the hints and tips I'm going to give will apply to more than one of these areas. So let's start by looking at the situation which I'm afraid is inevitable in business, that sometimes one party won't do what it's agreed to do. And Scott's going to talk a lot more about what happens when this occurs in the next part of our webinar. However, if you can put yourself in a strong starting position, you stand a much better chance of preventing that dispute escalating. Now, I know it's stating the obvious, but if you want a strong starting position to show that the other party's not done what they've agreed to do, then it's pretty obvious you're going to need a clear written agreement. Now, one of the advantages or problems, depending on which way you look at it, of English law is that it's very easy to create a contract. So frequently in English law, where there's an agreement between the parties, there is no clear written agreement. Rarely does English law actually require a contract to be in writing. There are one or two exceptions, such as an assignment of intellectual property, guarantees, and contracts for sale of real property. But for most commercial transactions, you don't need a written agreement. You just need three essential elements, which in legal terms are offer, acceptance, and consideration. And by consideration in the commercial context, we simply just mean a price. So if I offer to sell you my pen for £1 and you accept my offer, we have a binding contract. It's easy, therefore, businesses to get lazy in their contracting processes and rely on oral contracts. And that's absolutely fine until something goes wrong. Another consequence of the ease in which English law allows you to create contracts is that it's very easy to accidentally create a contract. So there's plenty of examples in case law where a sloppy exchange of emails has contained the necessary elements of offer, acceptance, and consideration, and a contract has been deemed to be created. Now, although I said a sloppy exchange of email, it can just be very everyday language. So an email from A to B saying, "I'll sell you my car for £1,000, followed by B saying, "Done, mate," that's a binding contract. Now, these problems can be avoided by heading emails with words such as subject to contract or other words demonstrating that you don't intend to create a binding contract. Now, this brings me on to another misunderstood area of heads of agreement. If you're involved in a large complex deal, it's often a good idea to initially sign what we know or what we call a heads of agreement. This is a document which sets out the basic terms, so the parties know they have a basic understanding as to the commercial terms between them, and they can then proceed to negotiate and agree a more detailed contract without worrying as to whether there's a fundamental meeting of minds on the headline terms. The problem stems from the use of the term heads of agreement. Unlike the term subject to contract, there is no magic to the words heads of agreement. Heads of agreement in practice tend not to be binding because if they're well drafted, they will contain a statement that they're not intended to create a legally binding contract. On the other hand, I've seen countless heads of agreement which don't contain those magic words, so they are in fact legally binding. Therefore, the lesson to learn here is that if you don't use words like subject to contract, but use words like heads of agreement, it's very often you'll actually find you're actually entering into a binding legal contract rather than actually having something which is just a non-binding understanding. The next area I'm going to look at is one that we frequently see, and that is that there is a fundamental misunderstanding between the parties. Often what you'll see happen is that two parties shake hands on a deal. One party then goes away and gets their lawyer to reduce that deal to writing, and a written contract gets sent to the other side, and they throw their hands up in despair going, that's not what we agreed at all. It's easy, therefore, to see how disputes can arise if there's a fundamental misunderstanding as to the deal at the outset. This is very much one of the important roles that we provide as lawyers, to get that deal reduced to writing and avoid those fundamental misunderstandings. Of course, reducing a deal or a contract to writing from scratch every time is going to be a time-consuming and expensive process. You don't want to be having to reinvent the wheel. And this is where standard terms and conditions or standard contracts are extremely useful. You can use the same contractual terms over and over again. So let's take a closer look at standard terms and their use. The great advantage is their ease of use, but there's also a price to pay and the problems that creates. The first is that it doesn't matter how wonderful your terms of business are, unless they're incorporated into the contract with the other party, they are in fact completely useless. I once came across a business which had spent a fortune on getting some terms of sale done, which were full of all sorts of protections, including a retention of title clause. I'll discuss that in more detail later, but it needed to rely on that retention of title clause when its customer became insolvent. It was genuinely in a state of utter bewilderment when it was advised that its terms were ineffective because they were not incorporated into the contract, and that it genuinely wasn't possible to incorporate the terms by actually leaving them in the bottom drawer of your desk. Other businesses try to incorporate their terms into a contract by putting them on their invoice. Now, an invoice is a post-contractual document. To be effective, you have to bring the terms and conditions to the other party's attention before the contract is made, and not after the contract is made, as in the back of an invoice. One of the problems with standard terms is what we as lawyers call the battle of the forms. And this is where you have a seller trying to sell on its standard terms of sale, and the buyer trying to purchase on its standard terms of purchase. And the battle is fought here as to whose terms are going to apply. Now, remember I said that to have a contract, you've got to have an accepted offer. But frequently what we find in the battle of the forms is that what appears to be an acceptance is in fact a counter offer. Now, there's a well-known case that illustrates the complexities of counter offers, and it also demonstrates that the battle of the forms is usually won by the party that fires the last shot with their forms before the contract is made. So I'll look at this case in a little more detail, and it's a classic and typical situation of A selling goods to B. So it kicks off by B asking A for a quote for certain goods on B's terms of purchase. A then offers to supply the goods on A's terms of sale. B then accepts A's offer, subject to acknowledgement of order on B's terms of purchase. Now, although that looks like an acceptance, it's not an acceptance, it's merely a counter offer, so we've still got no contract. A then sends the goods with a delivery note saying that A's terms of sale apply. Now, once B accepts delivery, a contract is going to be created. So it looks like A is going to win the battle of the forms here. But wait, what actually happens in this case is that B stamps the delivery note with a stamp saying accepted subject to B's terms of purchase. And the court decided, therefore, that B had won the battle of the forms there. Now, there are various devices that you can use to seek to win the battle of the forms, and perhaps the easiest and best one is to actually get one of the parties to sign a contract, because signing a contract will usually end the battle of the forms. So personally, I prefer to use standard contracts as standard terms, as it avoids any disputes about the battle of the forms. Another of the disadvantages of standard terms is that many businesses don't actually read them. So whilst you've got one party with a clear understanding of what they've agreed to, the other one hasn't. So let's look at here about having an understanding about what you are agreeing to. And I'll look here at some of the problems caused by standard terms and some standard agreements by not actually understanding what you're agreeing to. Of course, this can equally apply to bespoke agreements as well. But if you're aware of these types of problems, you can at least manage your expectations and not get caught, and thereby avoid disputes. Now, I'm afraid I'm a bit of a self-confessed legal geek. So when I'm asked to review a contract for a buyer, whether it's purchasing goods or services, the first page I turn to is the page that contains the exclusions and limitations of liability. If you are a buyer and the seller has limited its liability to a ridiculously low sum, then the rest of the terms are actually largely irrelevant. Those terms of the contract are not going to protect you, as the as a buyer because your remedies are limited or excluded. For example, and I'll exaggerate here for effect, but you might see a contract, let's say it's for the supply of an IT system, where the supplier warrants that its IT system is totally amazing and world class, but then goes on to limit its liability to £1,000. The most, therefore, the buyer can ever claim is £1,000. So in fact, that warranty that says this IT system is the most amazing system ever in the world is actually completely useless. Another small print clause that's often hidden well inside a contract, but often bites parties, is what we call a termination for convenience clause. A termination of convenience clause is a clause which allows one of the parties to terminate the contract, even if it has no valid reason for doing so. So you might get a contract which says the supplier is going to supply certain services for 2 years, let's say their IT support services. If there is a termination for convenience clause, the supplier can just terminate those services because, say, for example, it's no longer profitable for them to continue to supply them at any time during those 2 years. And as a buyer, you don't have any comfort, therefore, of having a 2-year agreement. All you've got is a contract which is at the will of the supplier. Perhaps one of the biggest areas of dispute I see is relating to scope. If you're a supplier of services, the extent of the services you provide will be set out in a scope, sometimes referred to as a scope of work, statement of work, and sometimes referred to as a specification. Now, scopes are often written by the business themselves and can be written in somewhat vague and ambiguous terms, therefore making a dispute more likely. Is something inside or outside scope, and therefore is it included or excluded from the agreed price? Now, whilst many lawyers take the view that the scope or statement of work is very much a job for the client to sort out, I'm firmly of the school that they should be reviewed by a lawyer to make sure there is no scope, forgive the pun, for a dispute as to what's covered and what's not covered. One of my biggest bugbears, and perhaps my biggest one, is agreements to agree. Agreements to agree are unenforceable. So a typical example might be a 3-year agreement for services where the price for the services is fixed to X pounds in year 1. And then we have, and to be agreed in years 2 and 3. Unless you actually agree the price for years 2 and 3, there is no agreement for years 2 and 3. If you want a binding contract and therefore want to avoid disputes in years 2 and 3, you've got to have a pricing mechanism for those years. So you might have an inflationary increase or some other formula. You might even have an expert determination clause as an alternative. So if we can't agree the price, we'll appoint an accountancy firm X, Y, and Z and Co to determine the price if we can't agree. Now, in my experience, having a third party as the final arbiter is a great way of getting the parties to reach a good and satisfactory compromise, as neither party can take the risk of that third party reaching a decision which is strongly in favour of the other party. Another common misunderstanding I regularly see relates to length of an agreement. So a typical example, let's say you've got a logistics provider and they enter into a 3-year contract with the customer to provide a logistics services for 3 years. When you review that contract, what you sometimes see is not a commitment to purchase logistics services for 3 years, but a 3-year pricing deal. In other words, the 3-year term fixes the price that the customer will pay, but does not guarantee that the customer will actually purchase any services at all. So I've seen plenty of examples where, say, partway through a 3-year term, let's say 6 months in, the customer stops buying those logistic services, and the logistics provider, in my example, wants compensating for those 2.5 years of the remainder of the term that they thought the customer was obliged to purchase from them. And it's never welcome news for that logistics provider to find out that the 3-year term that they agreed is just a pricing deal for 3 years. Now, if that sort of problem is spotted before signing, it's possible to negotiate a better deal for the logistics provider by giving them exclusivity, so the customer can't go elsewhere in that 3-year term, or having some minimum purchase obligation on the part of the customer, which guarantees certain monies to that logistics provider. And sometimes parties just don't get on. There's no breach of contract at all, and this is where, as you've already seen, a termination of convenience clause is quite useful. An alternative to termination of convenience clause in a long-term contract is to have periodic breaks, so that either party can get out at certain times by giving a certain amount of notice. As Scott will mention, when a dispute arises, you can agree some alternative dispute resolution mechanism, and sometimes, as I already mentioned, it's quite handy to build into your contract a provision that if the parties fall out in certain areas during the course of the contract, then the issue is can be determined by a third party. The next area I want to look at is a situation where the buyer doesn't pay. Now, this again inevitably happens from time to time, but there are some very simple steps that you can take to avoid making your position worse. None of what I'm about to say is rocket science. So first step, actually identify the buyer. Make sure you know who the other party is and get the correct name in the contract. Don't give a buyer an excuse for not paying because you've not named them correctly in the contract. Do a credit check on your buyer. Get a credit check on your customer. It's easy. You can even get one from Jordan's. I've seen clients on many occasions enter into contracts with shell companies, and by that I mean companies with no assets, but they are subsidiaries of larger corporates. Just because that shell company is owned by a larger corporate gives you no recourse to the assets of that larger parent company. The only way you can get recourse to those assets is through a parent company guarantee. But I see getting that parent company guarantee overlooked on so many occasions with consequences. Also, make sure if you're supplying goods that you have a retention of title clause in your terms. This will enable you to get back your goods where they've not been paid for if your supplier becomes insolvent. So how do we help our clients? Well, we help our clients by drafting contracts and drafting standard terms of business. We advise our clients on how best to incorporate their standard terms into contracts. We advise clients on contracts that they might be signing, how to get a better deal. We also help clients on negotiations. Now, negotiations is an interesting one. Sometimes you do need to be tough in negotiations. Now, that stance can sometimes damage relations. And obviously, if relations are damaged at the outset, a dispute may be more likely to occur later on. It therefore helps, I think, to have a third party such as a lawyer to lead or take part in negotiations. First of all, we're skilled negotiators, but secondly, we can be blamed if a tough negotiation stance is taken, and it thus therefore helps prevent the business relationship between the actual contracting parties breaking down if you can pass the blame for taking that tough negotiation stance onto your lawyers. So I've looked a bit now about avoiding and preventing disputes. I'm going to hand you back to Mark, who's going to introduce Scott, who will talk about what happens when a dispute occurs.
Thank you, Simon. So just a reminder again that you can email any questions to me. We'll address the questions at the end. My email address on screen, you can see mark_craig@jordans.co.uk. I just say before we move on, I think the battle of the forms really brings it to life to me, and I think the easiness, if that's the right way to put it, to make it how easy it is to make a contract. It's kind of terrifying in some ways. We could all do some, I think, consideration of that kind of almost danger to business. We're also joined, as I said, but to think about the prevention side of this, or the cure side of this, should I say, from our friend Scott Taylor. I'm going to move you on, Scott, and give us a little outline of what you're talking about today, please.
Thanks very much, Mark, and thanks for that, Simon, as well. So I'm a dispute resolution solicitor, and obviously I'm going to talk about what happens if you do get into a dispute, or first of all a disagreement, really, before it becomes a dispute. So what I'm going to look at first of all is just further reducing the likelihood of disputes, just following on from what Simon has said. Then the first steps that you may take if it's looking like you're going to get into a dispute, what you might do to negotiate or settle that dispute before it gets to a formal court process. And then looking at that court process, if you do get into that, how you might fund that process and the costs involved. And then finally, the pros and cons of litigation and what you might do going forward after you've experienced a dispute. So first of all, looking at further reducing the likelihood of disputes, and these really are typical things that I see when a dispute or a disagreement comes up, and it may be that they can be avoided or at least nipped in the bud before they come to me, really. So first of all, review the contracts that you have. As Simon said, the small print is part of the contract and is absolutely crucial. So, for example, a typical one I see is that people don't realise that there's a roll-on clause. So you'll have a period of a fixed period of a contract, say for 3 years, and then if notice isn't provided within the provisions of the contract, typically 90 days before the anniversary of the contract, then it rolls over for a further 12 months, whether you need that contract still or not. Then you'll find yourself with a £20,000 invoice for maintenance of your IT systems when you've actually contracted with another company because you thought your fixed term was at an end. So just know what your contracts say. Secondly, have effective customer service and complaints handling. As soon as you get a customer or contacting you to say, I'm not too happy with that, really engage with it so that you can continue that relationship and it doesn't become a disagreement. Have someone who is part of their job is dedicated to that role so that people know what the process is. Have effective credit control, so have a process in place. And if your credit terms are 28 days, then if you want to be hard on that, then really do keep to it. Again, have dedicated people for that role. You may decide that a customer is way too important to really come down hard on them if they do go beyond your credit terms, but at least have a process, at least have a think about it. Fourthly, keep a dispute log. You may find that you have the same customers making the same complaint time and again, and actually it's just an excuse for them to not pay or to pay very late. In that sort of situation, you may actually want to review the relationship and see whether you want to continue to do business with them. Also, what a dispute log may do is highlight a weakness in your contracting process. So to take an obvious example, if you did only put your terms and conditions on your invoices, then they wouldn't be binding in that contract, and therefore you'd want to review your contracting process, and a dispute log may highlight something like that. And finally, do keep on discussing things with your customers and your suppliers. Obviously, communication is key in business, and if you've got that trusted relationship, hopefully you'll never get into a disagreement or a dispute in the first place. So what happens if you do get into a disagreement? And I'm using the word disagreement on purpose here because actually that's how a dispute starts. It's actually a disagreement, and if you can nip that disagreement in the bud, then it doesn't become a dispute. So it's, it's very important to bear that in mind. But firstly, preserve the evidence, whether it's good or bad. You have a responsibility to do that if it does proceed to formal court proceedings. And it will really affect your credibility if, for example, your customer or your supplier brings out some evidence which you've said doesn't exist, and in actual fact it's your document or your email. A court's not going to look very kindly upon you not having that if you don't have a good excuse for it. And have a first think about what witnesses you may have to put your side of the story across. You don't need to do a full document, but it's just useful to sort of think about which employees have been working on the deal, who's the key account manager or something like that, and just get them to remember things on a contemporaneous basis, so that things aren't forgotten when the formal witness statements come around. I would encourage people to seek early legal advice. Litigation needn't be expensive and scary, but it often is, because people have entrenched positions. They've been trying to deal with things for 6-12 months by themselves. And so, people have said things which perhaps have been said in the heat of the moment, and people become stubborn, to be honest. Whereas if you get that early legal advice, firstly, you can know what the strengths and weaknesses of the case are, so you can hopefully try and negotiate with the other side. And secondly, we can give you straightforward tips that will nip the dispute in the bud. We often do this for clients, a half an hour telephone conversation, which we typically don't charge for, at the beginning of a disagreement can mean that you can go forward and resolve that. Gives you an objective view, as I said, so you can assess the strengths and weaknesses. And so I'd really encourage you to do that. Third point here is really have an early analysis of your position. Look at the contractual documents. Hopefully your terms and conditions are the ones that apply, and hopefully those are ones that Simon's drafted, so we all know they're correct. What are your rights and duties within those terms and conditions? Have you met them? Has the other side met their duties? Have you protected yourself? So, for example, if you deal in goods and you have a retention of title clause in your terms and conditions, have you labelled the goods sufficiently so you can identify them in the customer's hands? Assess the strength or otherwise of your case, and that will determine how you take it forward. And finally here, is there a dispute resolution clause such that you have to do that before you engage in anything else? For example, it may say that the MDs or senior executives have to meet on a round table without prejudice basis to try and hammer out a settled position. And going back to that without prejudice phrase that I just used, typically in litigation, you either talk on a without prejudice basis or an open basis. An open basis is, you owe me £100,000 because that's the value of the goods I've provided to you, therefore pay me £100,000. The without prejudice basis is, without prejudice to that position that you owe me £100,000, I will take £70,000 to settle this dispute. And that may be for a whole heap of reasons, whether it be commercial, whether you've identified a weakness, whatever it might be. And the importance of without prejudice is that if it does go to a formal court process, then those without prejudice negotiations will not determine the outcome of the trial, so the judge won't know that you would accept £70,000. All he will know, or she will know, is that you are owed £100,000 and you maintain the fact that you are owed that £100,000. The without prejudice position only comes in as the costs, but it's best that we talk about that if and when you need my services, because it's a reasonably complicated area. Have an early strategy to resolve any dispute. So what do you want to achieve? Do you want to maintain the relationship? Even if you don't want to maintain the relationship, do you want an amicable resolution? Or do you want to make an example of the other side? For example, you don't accept bad debts, and for example, you want to enforce restrictive covenants to protect your business. So moving on to what might happen if you wanted to negotiate a settlement, maybe that you enter into an initial negotiation by yourself with the customer or the supplier, hopefully with that early advice that I've just talked about. Set internal parameters, so what's the minimum you'd accept, and as I've just talked about, be careful of the basis upon which you conduct those negotiations. You can enter into alternative dispute resolution at this point. Indeed, you can enter into an alternative dispute resolution at any point in a dispute, all the way up to trial if you want to. And what this is, it's a more formal negotiation, takes many forms. So for example, a round table meeting with or without legal representation, through to a mediation. Hopefully it will be commercially based, but certainly the timing is quite important, especially for mediation, because the legal issues have to have been sufficiently cooked. Otherwise, actually, especially if you've got lawyers there, which you would do for a mediation, you just debate the legal issues rather than concentrate on the commercial issues, i.e. how much is the defendant going to pay and how much is the claimant going to accept. What it does do, especially mediation, is offer an objective, independent view. So it can be quite useful for just battering through any entrenched positions. Yeah, as I said before, you can negotiate a settlement at any time in the process. It's not a now or never thing. It can be right up to trial, and indeed during trial if you've got a multi-day trial. Finally, do make sure you have a formal agreement if you do settle things. Make sure terms are signed up. I would say that you're far better having a written agreement, just a new contract essentially, but at the very least make sure it's recorded by email, because it does avoid confusion or doubt in the future. And make sure it's signed up if you can there and then, because what you wouldn't want is for a settlement to have been reached and then one party get buyer's remorse and pull out of that, because all you've got until terms are signed up is, to go back to what Simon's saying, is an agreement to agree, no contract until you've signed up. So what happens if you don't manage to settle things at that early stage? Well, you'll probably end up getting into the sort of litigation process. The first part of that is to abide by what are called pre-action protocols. These are set out in formal rules called the civil procedure rules, and there are a number of these which apply to different areas of disputes, whether it be debt recovery, professional negligence, and if there isn't a specific one that applies, then there is a general one that applies. And essentially what these say is that the claimant has to send a letter of claim to the defendant, and that sets out his case, his or her case, what documents they rely on, and what remedy they're looking for, typically money, but it could be, for example, an injunction or a declaration or something like that. And then the defendant has a set period of time to provide a letter of response, giving their side of the story, essentially. And what the pre-action protocols do is hopefully narrow the issues and again encourage settlement. After that, if the dispute is still ongoing, then you move on to formal court proceedings, which essentially involves a claim form particulars of claim, and you'll typically instruct a barrister at this stage to draft those particulars of claim. The particulars of claim are the legal basis of the claim. There may be some facts in there as well, but primarily the facts come later in the witness statements. This is just setting out why, on a legal basis, you say you're right. There's a fee involved in issuing court proceedings, and that's dependent on the value and the remedy that you're looking for. Once those proceedings have been issued, then the defendant has to file a defence, and then you'll move on to a court timetable. These are formally called directions, and they are set at the first hearing called the Costs and Case Management Conference. It's largely an administrative hearing, and what it does is it sets out the court timetable, which is typically disclosure, which is when the claimant and the defendant say what documents they have that are relevant to the dispute, essentially. Then it'll be witness statements, which is the facts which each party is relying on to back up their legal case or defence. There may be expert evidence depending on the nature of the dispute. There'll be a further administrative hearing just before the trial, just to make sure that everything's ready for trial, and then there'll be the trial. On the assumption that you are successful in getting judgment if you're the claimant, then you may then have to enforce that judgment if the defendant doesn't pay up voluntarily. You'll have looked, hopefully, at the prospects of recovery beforehand, and a lawyer can very easily do this for you, because what you wouldn't want to happen is that you get all the way to getting judgment, spent that time and that emotional energy doing that, and then all you have is a piece of paper to show for your efforts, because if you can't enforce the figure that's on that piece of paper, then you haven't really achieved anything. So do look at those prospects of recovery before you enter into at least formal legal proceedings. But as to the method that you'd use to enforce that judgment, really depends on the makeup of the other side. So it may be that you instruct bailiffs or High Court enforcement officers, if they've got plant and machinery that you could take and sell. If they own their building, then you may be able to get a charging order and an order for sale, or indeed you might be able to go down the route of insolvency. So looking at funding of that litigation, and the costs involved. Costs aren't necessarily an formal issue between the parties pre-action, but you can use them as a bargaining tool in any settlement before you take formal legal proceedings. In proceedings, they definitely are an issue, and what I mean by that is the judge can make orders as to who pays whose costs. Again, the parties can settle on whatever terms they want, so they're not bound to address costs in any settlement, but the court will make orders to do with costs if there are formal proceedings. The general rule on costs is that the loser pays. There are some caveats to that, being the value of the claim. Sometimes there are fixed costs, and whether any without prejudice offers have been made, and also subject to judicial discretion, for example, if there's been any unreasonable behaviour by the parties during the proceedings. How much can you expect to recover? Perhaps not all, but it should these days be the vast majority, given that we now are in the era of what's called cost budgeting, which is where the judge sets how much each side should be spending on each of the areas of litigation. Now that's subject to your agreement with your solicitor, but there's no reason really why a solicitor shouldn't be able to keep to those cost budgeted figures. You may fund litigation through a no-win, no-fee arrangement with your solicitor, formerly called a conditional fee agreement or a damages-based agreement. The downside of that is that you probably don't keep all of the damages, because some of them will go to pay the uplift in the solicitor's fees through a conditional fee agreement, or indeed a percentage through the damages-based agreement. But what it does is reduces the risk for you, and any cash flow issues that entering into litigation may cause. Finally, on this slide, do look at insurance, whether it be before the event insurance attached to any pre-existing insurance policy you have, or after the event insurance to cover any costs that you may have to pay to the other side should you lose. So what are the pros and cons of litigation? Well, the pros are that you maintain your relationship with the other side. You show that you're a strong business, that you're not going to take things lying down. You protect that business, you enforce your rights, and you hopefully get paid and compensated. The cons are it can be time consuming and expensive, but with the right approach, it shouldn't be. If you are in a dispute and it shows defects in the process, do look at those. So, for example, have you got a decent due diligence on new customers and suppliers, credit checks, etc., and look at your contractual documentation to make sure that's up to date. Review your customer and supplier list. Are you still happy dealing with them? And do review your position on a regular basis. As a business grows, potentially other issues arise beyond simple contractual disputes, and you need to protect your business, for example, with restrictive covenants on your employees. And finally, just re-emphasize, do seek early legal advice, because that will put yourself in the best position not only to avoid disputes, but also when a disagreement or dispute arises. Okay,
thank you, Scott. I think it's a fascinating, albeit whistle-stop tour through the core processes. I think it's very helpful to understand the complications potentially within that space. We now have an opportunity for some questions. So again, on screen you can see my email address, mark_craig@jordans.co.uk. Please do send any emails across to us. We can address them in this session. Any we don't get to answer today, we can answer by email after the event. But we have a question that came through earlier. What if my customer pulls out of an agreement despite emailing that they've agreed to buy? I think you're talking about a service or a product here, and I guess this is a contractual question, maybe for you, Simon, the first one.
Yeah, good question, and actually it's something that back in the day when I first started my legal career, I was actually a corporate lawyer rather than the commercial lawyer. And actually had this very similar situation to this. I won't say which party I was acting for in this particular scenario.
Please don't.
But it was a sale of shares, and I think the sale price was something like £2 million, and it had got to a stage where the negotiations had gone, for several months, and at literally the 11th hour, the seller decided that it would up the price from 2 million to 2.5 million, and so unsurprisingly the buyer was not very happy, and a fax was found from the seller to the buyer. Sorry, fax shows my age, but that's how long ago it was. And a fax was found from the seller to the buyer saying, "Thanks very much for your offer. We agree to sell 100% of the shares of Exco Limited for £2 million." And it's very interesting because actually that situation, that was almost certainly a binding contract, despite the fact that one of the parties sought to argue that it wasn't, but it was certainly sufficient to bring the parties back to the deal table and agree to sell for the £2 million. So, it is, and I said earlier in my talk, it's very, very easy to create contracts if you just have an exchange of emails which contains the necessary offer, acceptance and consideration. And offer can be a verbal offer, and acceptance can be I agree to sell for X pounds, whatever it is. You have got the necessary elements of a contract, and that is a contract, and you've created it by email.
Great. So that's I think the point about you're easy to make a contract brings it to life a little, doesn't it? We do have another question. Again, if any more questions, my email address is on screen there. Question, I'm going to paraphrase it a little, I think. So I have a customer who won't pay, so I plan to formally tell them that they should pay. Can I do that without a lawyer? So I guess this is in the space when they're maybe approaching a point at which they're in the dispute. So maybe one for you, Scott.
Well, the simple answer is yes, you can. As I said during my part of the talk, you know, there are those initial steps that you can take, those initial negotiations that you can take to see if you can settle things before formal proceedings. But as I said during my talk, I would encourage that you take early legal advice because the nature of those negotiations may be impacted by the strength or weakness of your case, and getting a little bit of input from a lawyer, whether that's the quick half-hour telephone call that I talked about or not, I would say be very useful. Moving on from that, if as the question may imply, you're at the position where you've had those negotiations and your customer just simply is not paying, then you would be moving on to that pre-action protocol stage where you're sending a letter of claim. Now, this is an absolute vital part of any dispute. What that letter of claim does is it sets out your claim, and there are certain things that have to be done. If they're not done, and therefore you haven't abided by that pre-action protocol, then if it gets to court proceedings, then you may be what's called penalised in costs. Because you haven't set out your case sufficiently to the defendant so that they're aware of the risks to them. And they might say, well, had I known that Exco Limited, their case was this, then of course I would have settled, because that shows that my case is weak, and therefore Exco Limited have caused me to incur all these costs by not presenting their case in accordance with the pre-action protocol at the very beginning. So that's the sort of technical side. The strategy side, which is vital in litigation, is that this is your first opportunity to really tell the other side why your case is good and why their case is bad. So it really needs to be a very good letter, that letter of claim, to really put you in the strongest position to either hopefully settle a claim or put you in a strong position if it's going to go to formal legal proceedings. So yeah, the easy answer is yes, you could do it yourself. The more complex answer is I would encourage you to instruct a solicitor.
It may be more complicated indeed.
Yeah.
Okay. Again, email address on screen if any questions that people want to address, but in the meantime we will address them by email after the event. But in the meantime, I do want to respect everyone's time, so we're going to start wrapping it up there. We'll move the slide on to contact details if anyone wants them. So thank you for joining us this morning. We hope you found it useful. Any questions we received we will address after the event. We have made a recording of this event today, and this will be available to listen again from our website. So if you your colleagues want to listen again, you can do so. Please also keep an eye out for future free webinars at the Jordan's website. Until next time, thank you and goodbye.
Thank you, bye.
Thank you very much. Bye-bye.